So you've got a statement that says, at 4 p.m., the light was green. You have that in a transcript somewhere, in a defense statement, in a grand jury statement. You have 4 p.m., the light was green. So I would encourage you to confirm using the language closest to that as you possibly can. Your most recent story, so you're signaling to the jury something is coming. Your most recent story is at 4 p.m., the light was not green. So now you're confirming what the witness is claiming. You're confirming the most recent testimony. Now you're confronting the witness with the prior inconsistent statement. And the method through which you do that depends, right? What are you trying to accomplish by impeaching this witness? Are you saying that the earlier version was true? Or are you saying the witness is just inconsistent and therefore unreliable? Neither version is true. The witness is just not accurate. What are you trying to prove? You have to know that before you start impeaching the witness. The first version was true, or neither is true. The witness is just inconsistent and therefore lying. The method through which you confront the witness will depend on what you're trying to prove. So here, in the first example, you're trying to establish that the earlier version was true. So here, I would encourage you to lay a foundation as to all the indicia of truth, right? Who was there when it happened? The prior statement happened closer in time than we are today in court. The prior statement was under oath, maybe it was signed. Build up everything that shows that prior statement was true. Practice tip. You may get some prosecutor, if you impeach, and then you stand up in closing argument and try to use that impeachment to say that the prior version was true, you may get some prosecutor that stands up and says, objection, that impeachment was not for the truth of the matter. There's nothing to say that prior version was true, judge. So the defense counsel was arguing improperly. So if you want to argue that the prior statement was true, I would encourage you to ask the question, what you said in January, that was true, right? When you were talking to the grand jury, you answered questions, yes. You answered them completely, yes. Accurately, yes. Truthfully, yes. And the truth that you gave in January of 2021, that's still true today, right? Yes. And then you go and impeach. So now when you're in closing argument, you can argue the truth of the prior statement. Because if you don't, you may get some prosecutor that stops your closing argument and says, counsel was arguing improperly, arguing the truth of the matter. That was an out-of-court hearsay statement that was not admitted for the truth. So that's a tip that I would encourage you to incorporate, or at least think through whether it works for your practice.
We've heard testimony from the SANE and sex crimes detective and the ADA, because the ADA has said now that it is seminal fluid, it's sperm, and it's in the anus. So now let's look at what the lab report actually says. This first page really is nothing. It's just the inventory of, every page should have an inventory of, let me just show you this real quick because I've got demonstratives. And I'm not even a lawyer. So I'm going to mark this 1. This is just your typical evidence collection kit. At the lab, open that up, and they do an inventory, and that was what that first page was. If anybody wants to look at that, it's right there in a bit, or now, whatever. So body fluid examination, that's serology. So what did they find in the body fluid? Well, the anal swabs, see how that gets passed down? It's misrepresented all the way now. It got misrepresented by the SANE nurse because we know that it's a butt swab, not an anal swab. And so now the lab's calling it an anal swab. And it was that we conducted a presumptive test with an AB card, indicates the possible presence of seminal fluid. Microscopic examination was conducted. No sperm on everything except the anal swab. Some blood on some of the other swabs, but we're only looking for DNA purposes at the anal swab because that's where the possible semen, no sperm, but possible semen was. So DNA extraction was performed. Let's see. I underline all of this really important language that you need to be looking for when you're looking at your DNA lab results. If you see my little high quality PowerPoint presentation, I mean, how many times have we heard sperm, semen containing stain, anal swabs, sperm cells? This is what your jury is hearing eventually, or possibly if you don't do some motions to make it not happen. And so what we do learn is that the alleged victim is in the sperm cell fraction. We're going to talk about that a little bit later. So they get this report, unknown male. Of course, they go and chase the suspect down. And so we get this report after they have the suspect's known DNA. And basically, it repeats all of this sperm cell fraction, victim, epithelial cells are present in the sperm cell fraction. It just repeats it, except it puts the suspect there. So what I want to know as an expert is how much DNA is there? Because I know the defense hypothesis and I know the prosecution hypothesis. So I want to understand how much DNA is actually there. So we look at these things that are just fun and super quick to look at. So when you get a bill and there's like 10 hours looking at quants, I want you to know that that's kind of what it looks like for us. And it's so fun. But fraction 1, their non-sperm cell fraction, total amount of DNA, autosomal DNA, is 6.3 nanograms per microliter. That doesn't mean anything to you, except when I tell you that a picogram is 1,000th of a nanogram. And all of our kits that we amplify with, we are targeting 1 nanogram of DNA. So we're going after 1 nanogram. A picogram is 1,000th of a nanogram. So it's really, really small. So in the Y, in the male portion on the non-sperm cell fraction, there is 19 picograms. 6 picograms is equivalent to 1 skin cell. So just wrap your head around that for a minute. I do it all the time. In the sperm cell fraction, 16 picograms of DNA, 16 picograms of male DNA in the sperm cell fraction. Anybody can do math really quick. That's about 4 cells total. That's not a lot of DNA. Does that go, you start thinking about the facts of the case, does that go with, minutes or hours of anal sex? No. Or I hope you're thinking no.
Okay, now we're at scaled questions. Here are the keys. No more than 2 to 4 questions. Any more than 4, and the only place you're going to do 4 questions is my hour-and-a-half venue and my unlimited time venues. That's the only place you'll do more than 4. Okay? But for the rest of us mere mortals that have these horrible time limits put on us, 2 is probably the best you can do. 2 scaled questions. Next. Use a scale of 1 to 5, 1 to 7, or 0 to 10. So, the reason you want to do that is you want to have an odd number of choices. The reason why you want the odd number of choices is so you have a true neutral number, a true number in the middle. Okay? So that's why I typically use 0 to 10. You'll see some examples in just a second. The questions must be proper. They can't be improper questions. The judge will absolutely shut you down. Prosecutor will object. The questions must be relevant to cause or peremptory strikes. Okay? And remember, Peremptory strike, cause has a real limited, avenue, whereas peremptory strikes is much broader, right? Because peremptory strikes is what your sense is of the juror, not whether or not they're legally qualified, but what your sense is. So that's why you have more latitude. If you argue, Judge, the reason why I want to ask this question, it helps me intelligently exercise my peremptory strikes. All right, next. Spread them out over the voir dire. Don't do them all at once. Do one in the beginning, do one in the middle, do one at the end. If you're only going to do two, do one in the beginning, do one at the end. Next. Ask every juror for a number. You don't want their answers. You don't want their reasons. All you want them is to give you a number. You're just going to write down the numbers. All you're going to do. The number that best reflects their answer to the question. And then never let any jurors explain their numbers. Never let a juror explain their number. So here's how all this works. Let me show you some examples. The right to a fair and impartial jury is the cornerstone of our democracy and freedom. 0 is strongly disagree. 10 is strongly agree. Or any number in between. Here's another example. Even trained police officers can jump to a conclusion and can be wrong. Even trained police officers can jump to a conclusion and be wrong. 0 is strongly disagree. 10 is strongly agree. Test results, Brad or bluff, whatever you have in your case, can be wrong. 0, strongly disagree. 10, strongly agree, any number in between. I want y'all to start thinking that you can come up with better questions than I can, because you guys do this, you live this day in and day out. These are kind of the ones that I've come up with. Come up with some of these scaled questions. And all you're going to ask jurors is to give you a number. You're going to have somebody, that person that's going to help you with jury selection. I'm going to show you the chart in just a minute. They're going to write down all these numbers and add up the numbers so you'll know who are your unfavorable jurors that you need to go for cause on and who are the jurors you need to exercise your peremptory strikes if all your challenges for cause have been granted. Some people will fail field sobriety coordination. I like calling them coordination tests. This field sobriety test, you should never use those words. You should excommunicate them from your vocabulary. Okay? Because all you're doing is feeding into prosecutor words. Like confession. As soon as it comes into evidence that your client gave a confession, all the Catholics on the jury are convicting your client. Because that's who confesses. Okay, so don't use confession. Don't use field sobriety tests. Call them what they are. Coordination tests. Even when they're sober, right? Some people will fail field sobriety tests. We're going to use coordination tests even when they are sober, 0 to 10. Having 1 or 2 drinks does not necessarily mean a person is intoxicated or impaired. Alcoholism is a disease. Wow, you want to open a can of worms. On this question, do not let any of these jurors talk. Okay? All hell will break loose in your in your courtroom. Don't let them to just give a number. Just give a number.
So give us the analysis.
Oh, whether or not, well.
Yeah, they seem obvious, but
Yeah, I see two sides too. I personally believe that the disease side is a better juror for you than it's not a disease. I think you do want the disease side. Absolutely. Because they'll at least understand, especially if you've got a client with priors, they'll understand why it is that how is it he's still drinking and driving if he's had all these priors? And the reason is because he's got a cancer called alcoholism. Right? We don't like to put people with cancer in prison, do we? I didn't think so. If at the end of the case I was not sure if the state proved their case, my verdict would be not guilty. This should be your last question. Every time. This should be your last question. If the state did not, if I was not sure, if the state proved their case, my verdict would be not guilty. Get the scaled question first, then explain to them the law. The law says they have to vote not guilty. But get their scaled number first to see intuitively where they start, and then teach them the law. Here's the chart to keep track of it. Send me an email. I'll give it to you so you can use it. That's for scaled questions. We have, see, this is how it gets filled out, right? Probably guilty or disease. In Texas, again, it's punishment. So this came from a Texas case. So you can see, under my theory, the higher the number, the better the juror. The lower the number, the worse the juror. Now, some of you say, Robert, you're going to out my good jurors. You don't have good jurors in your venue. They all moved to Aspen. Okay? Don't worry about outing your good jurors. You want to identify all your bad jurors. You can do the same kind of, here's another chart for keeping track of your challenges for cause, right? At the top is where, at the top up here, screw it. At the top, reasons for cause is a letter, and then those are the juror numbers, in this case 1 through 60. And then that way, when a juror says something, if it's if the juror said that they can't be fair in a DUI case, I would give that the letter A, and everybody who said that, every juror number that said that, they would get the letter A. So you can manage and intelligently figure out who your peremptory strikes are. Here's an example of it filled out. You just see by looking at that chart who should go for cause. Just by looking at it, you could see who should go for cause.
So I'm going to give you 2 terms. Fixed insanity and settled insanity. How many of y'all have heard of fixed insanity? Settled insanity. All right, so I should see a lot of hands writing. So fixed insanity. As a result of your substance use, the person now has a permanent condition. So fixed insanity, as a result of your substance use, the person now has a permanent condition. So it's a mental disorder brought about and remains. That means it's long-term, it is permanent. Whereas settled insanity, it settles in. The period of the psychotics, I'm talking about psychosis, the period of the psychotic disorder is past the point of intoxication, meaning when you drug test them, they don't have the drugs in their system, but they're still experiencing the psychosis. So it's past the point of intoxication, but it does not last forever, okay? So taking cocaine hypothetically, may have developed a paranoid psychosis, then an act was committed that was delusionally based, although the substances are no longer in their system. So they get arrested, they have a drug test, substances, you're like, yes, it's in there. 5 days later, substances not in there. But by the time you get a mental health professional on board, they are like, this person is saner than sane. Like, there is no psychosis. What are you talking about? So that means no longer a direct effect by the substances in the person's body, okay? So settled insanity, for a period of time without substances, this person is still experiencing psychosis. But then after the symptoms remit, they present as typically functioning, okay? And some people are like, okay, well, that means the substances actually did produce the psychosis, which happened when they committed the crime. But you have to know your jurisdiction and law. I'm not an attorney. I don't know everybody's jurisdiction, but just giving you these words and these definitions of how does this match up with the law that is in your state, fixed insanity versus settled insanity. So again, questions to ask. Does sufficient historical evidence exist that the person experiences genuine psychiatric and psychotic symptomology? So do you have enough information to say this person had genuine symptoms pre the use of a substance use? Another question, is there evidence of mental illness symptoms prior to substance use? Okay, so one is sufficient historical evidence of genuine psychiatric and psychotic symptoms. The other one is there evidence of mental illness symptoms in general, even if it wasn't psychosis? Let's say the symptoms were depression or PTSD, or maybe they have OCD or even an eating disorder. Was there any type of mental symptoms going on prior to this? Okay. And then overall, what was the behavior before and after psychosis? How are they presenting and acting before psychosis? How are they presenting and acting once they're on their medication, or maybe the symptoms have remitted completely? All right, case 2. Now, this particular case, the main point of this case is conflation. Who knows what conflation means? Or confabulation. Conflation or confabulation? Is that a hand? Fantastic. So hold that thought in your mind. Conflation, confusing two different factors, or in this case, two different events, possibly as one event. This was a mother and son. I was brought in to evaluate the alleged victim, which so happens to be the mother. And the mother had complex trauma starting in childhood, and horrible complex trauma starting in childhood. Sexual abuse, sexual assault, multiple rapes. The alleged incident was that the son harmed the mom and was holding the mom captive inside of their home. But the son also had history of suicide attempts, mental depression, and the mom, white, son, biracial, but more presenting features of African American. In this particular county, specifically in this particular city, in this particular county, the mom was weary of calling the police because she did not want her son. Y'all see where I'm going with this? Okay. So why did I bring up conflation and her history? The DA point, of course, was any parent would lie to protect their child. Makes sense, right? Very logical, sound argument, especially with a jury. But I was arguing that she was engaging in conflation or confabulation because of her complex, untreated, never been to therapy, and she was in her late 40s. Because of her complex, untreated, multiple child sexual abuse, sexual assault, rape incidents, because of that, she was conflating that the reason, which was a rape, was her son. Are y'all tracking me? No? She was mixing up the stories that her son was an abuser or a perpetrator versus the actual story. And that happened as soon as she was interviewed by the police. You backtrack, let's say it was about 9 months later, she watches her interview by the police and she's like, that never happened, and what is this? She was like, no, it was these two guys after my work, then I went home and I talked to my son. So now her memory is starting to come to and settle together. And I encourage you to watch my presentation in April because I talk a little bit about memory, and this will make sense. I'm just trying to speed through this. But the point is that some people have so many traumatic experiences that they're never consolidated. And when another traumatic experience happens, they can conflate or they can mix the two events. Now are you tracking me? Does that make sense? So memory and trauma, in this particular case, it mattered hugely, but the main barrier for this case, it was that it was a mother and son, and that whole argument, do parents lie for their children? As much as we had more evidence that she wasn't lying, morals.